in mind. One begs to answer the question as to whether the subject matter of this application and petition are indeed matters employment and labor relations or strictly restricted to the jurisdiction under Article 163 3D1. The petitioner submits.
All right, let's now speak to our reporter Murimi Mwangi live from the Kericho Law Court, who was in court during the delivery of this particular ruling. Good afternoon, Murimi. Thank you for joining us. What exactly does this ruling mean for civil servants intending to vie for various positions in the August 8th polls?
Good afternoon, Akisa. The immediate upshot of that particular ruling is that the IEBC cannot disqualify civil servants that have not yet resigned pursuant to the initial provision of the that particular law that is now in contention before the court here, that which stipulated that civil servants have to resign 6 months to the election, a deadline of which was on Tuesday last week. Besides that, the ruling also means that civil servants that are eyeing political positions in the August 8th general elections are going to earn their salaries for the month of February. Remember, pursuant to the initial law or the initial provision of the provision of that law that is now subject to the case that is before court, they ought to have resigned by Tuesday last week. But the ruling, of course, comes as a result of an application that had been filed here by the IEBC and the Office of the Attorney General in that particular petition, arguing that the Labor Relations Court does not have jurisdiction to hear disputes which are with regard to interpretation of the law. And the judge here ruled that the issue in question here in that petition filed by a civil servant from Kipkelion is one that falls within their jurisdiction, being one of a dispute between an employee and the employer, in this case the government and a civil servant. And of course that touches on human rights, which is part of what the courts are set to enforce, including the labor relations.